It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. Yeah, what you know about the first comp and the rent due, and you late. Yeah, what you know about your girl call and a miss due, and she late. Yeah, what you know about showing up to work in the rush and you 30 minutes late. We call them regular days. Yeah, that's just another day. Yeah, try to be punctual, tailor fitted like Huxtables. Feel like I'm sacrificing my pride to be comfortable. Life in an endless cycle, carving a lane to lock in my spot like it's vitiligo. I guess I feel like Michael. The press turning, got my chest burning. Only option left is collect the earnings to make a successful verdict. But shit, I'm 30, trying to get in the game. At this point, what it's gonna say when folks remember my name? Was I your late bloomer? Should I have made it sooner? These out-of-state rumors surfacing on their computers. Part of my frequency, but niggas been tripping, I got the remedy. Trying to belittle me, only tarnish your energy. Forgot my homies handshake in the hood. They say I can't return, I guess they gon' stay there for good. But that's another beast I won't address. My motive said I'm over that. Focused on this union like the Soviet is sobering. Mind playing tricks on me, this shit is brand new. All my niggas got a list of phobias they can't do. Like commitment to their girl, or resistance to the world. I'm just waiting for my moment to unfurl. Yeah. What you know about the first comp and the rent due, and you late. Yeah, what you know about your girl call and a miss due, and she late. Yeah, what you know about showing up to work in the rush and you 30 minutes late. We call them regular days. Yeah, that's just another day. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this Sunday evening. Happy Mother's Day once again to all the ladies out there. You know what I mean? Now, y'all know we've been keeping close tabs on this whole Drake versus UMG legal dispute lawsuit from Mr. R.B. Drake Graham. Okay? Just last week, we talked about UMG's motion to dismiss, right? They had to file that paperwork. Drake will have until the end of this month to answer to the judge why he believes that his case shall continue, right? So that's where we stand at this current moment. However, new paperwork has been filed coming into this weekend. All right. I'm just now getting the opportunity to talk about it. It's been out there for a couple days, but there has been a proposed protective order. All right. Over the discovery phase, meaning that certain pieces of discovery will be restricted for only attorneys' eyes only. All right. Restricted from the public, even restricted from the actual parties involved in the case, just the attorneys. All right. So sensitive information, perhaps contract details, things, personal addresses, things of that nature probably don't need to be out there. They're trying to keep those things concealed. I've seen some misinformation being put out there that UMG is trying to hide some things, but I want to show y'all the background. If you haven't already seen this anywhere else, I want to show y'all the background of who uploaded this information and this proposed, protection. All right. So we're inside of here. May 9th, this was filed on Friday, joint letter addressed to Judge Jeanette A. Vargas from M. Annie Houghton Larson. Okay. Response: proposed protective order to govern discovery document filed by Aubrey Drake Graham. Attachments: number 1, Exhibit 1, proposed protective order. Exhibit 2, proposed protective order, red line, entered May 9th, 2025. So anybody telling y'all that UMG is reeling back and they're trying to conceal all of this, this is coming from both parties, but this was literally uploaded by Drake. Okay. Now, also, if you look down here on the order from the judge, the protective order was not executed properly. Okay? Now, executed means signed. It has not been signed. Although it is a joint filing coming from Drake, the parties should resubmit with the signature lines complete, meaning nobody signed on to verify their agreement. It's just a proposed order. For whatever reason, Drake jumped ahead of the gun and put this in before getting signatures. So they're going to have to re-upload this. But while it's here, let's just look at the contents of what it is they're proposing. Okay. Okay, so up top, you see the letterhead. This comes from Wilkie Farr and Gallagher LLP. That is the law firm that represents Drake, once again. And this is a letter to the judge informing her of the proposed protective order. So they say, Dear Judge Vargas, pursuant to Rule 5N of the court's individual rules, the parties submit this letter in support of the jointly filed proposed protective order to govern discovery in the above captioned case attached as Exhibit 1. Pursuant to the court's individual rules, the proposed protective order conforms as closely as possible to the court's model protective order based on what the judge suggested. The parties have proposed certain limited changes to the provision regarding the use of the attorney's eyes only designation. Okay, so they're requesting some modifications to what the judge wanted to see. Attached to this letter as Exhibit 2 is a black line, aka red line, showing the changes to the court's model protective order. The reason for this alteration is that the parties agree this case is likely to involve the production of certain categories of highly confidential or proprietary business information, specifically previously undisclosed contracts and information regarding business relationships with non-parties to this litigation, the disclosure of which would be highly likely to cause significant harm to defendant UMG Recordings or plaintiff Aubrey Drake Graham. Okay? And once again, I've been seeing misinformation circulating online about the nature of this jointly proposed protective order of people saying UMG is trying to hide. Okay? Now, if y'all can remember, Drake is requesting the contract of Kendrick Lamar. He's also requesting the contracts of all notable UMG recording artists because he wants to show, based off of his information and belief, remember that, keep that key, that UMG is supposed to have a no release veto clause in their contracts, where if they deem something in your song to be labeled as defamatory or something that is not up to par with UMG's guidelines of protective, what they feel is necessary to put out, if it goes against their code of conduct of what they believe is suitable to be released, they'll exercise their veto power and say, you can't drop this song. Or you can't drop this song without making the necessary changes at our request. And of course, this is pertaining to Not Like Us, which he wanted them to literally stop him from releasing. They also wanted Drake also wanted UMG to force Kendrick to edit out certain bars on that song in order to stay up. UMG ignored all of those requests. Therefore, he wants to see everybody's paperwork to show, based on information and belief, we all have this clause in our contracts. Why did y'all willfully ignore this? Because y'all could have put a stop to this song coming out and defaming my character. That is Drake's position, right? Not to mention, he's also asked for, he wants to see the marketing tactics. He wants to see all communications between third parties who had a hand in promoting Not Like Us, right? To see if there were any nefarious incentives or benefits given outside of legal restraints to magnify Not Like Us as a bigger song, right? And he wants to see all of those communications, emails, text messages, any payments that have been sent, all things that technically we're not supposed to see. But of course, he wants his team to be able to see it so that they can find deficiencies in what they have going on in order to incriminate UMG in their dealings with Kendrick Lamar, right? Just giving y'all context. So the parties submit that discover, and of course, they want to also protect Drake's contract, right? They don't want people like myself or other people in the public to be able to dissect the specifics of his contract with UMG, right? So they're asking the judge to allow a little bit more restraint to be put on these sensitive documents. I'll continue. The parties submit that discovery will be more efficient if the parties have the ability to designate these limited categories of documents as attorney's eyes only without needing to provide notice and justification on a document by document basis. So they don't want to have to keep asking, hey, judge, can we protect this piece of information? Can we protect this document? They want to have specific categories. Once again, that is for undisclosed contracts, highly confidential or proprietary business information, and information regarding business relationships with non-parties to this litigation, which also, if we're going to be all the way real, it also could include Drake's business relationships with non-parties who are perhaps criminals or unsightly people in terms of the law, right? So they also want to protect his relationships with those types of non-parties who are not defendants or plaintiffs regarding this legal dispute, right? So everybody's looking for some level of protection. They can't protect you in court, but they can protect you from the viewing public who are reading this stuff for their own purposes, right? With respect to all other categories of documents that the parties wish to designate as attorney's eyes only, the parties will follow the standard procedures set forth in this court's template. Respectfully submitted, M. Annie Houghton Larson. Okay? So that's the letter. But then there's also some additional documentation here. Here we have Exhibit 1. Okay? Protective order, Aubrey Drake Graham against UMG Recordings, Jeanette A. Vargas, the judge. They say, whereas all of the parties to this action, collectively the parties and individually a party, request that this court issue a protective order pursuant to Federal Rule of Civil Procedure 26C to protect the confidentiality of certain non-public and confidential material that will be exchanged pursuant to and during the course of discovery in this case. Whereas the parties through counsel agree to the following terms. Whereas the parties acknowledge that this protective order does not confer blanket protection on all disclosures or responses to discovery, and that the protection it affords only extends to the limited information or items that are entitled under the applicable legal principles to confidential treatment. Whereas the parties further acknowledge that this protective order does not create entitlement to file confidential information under seal, and whereas in light of the foregoing and based on the representations of the parties that discovery in this case will involve confidential documents or information, the public disclosure of which would cause harm to the producing person and or a third party to whom a duty of confidentiality is owed, and to protect against injury caused by dissemination of confidential documents and information, because some people that are not involved would have their information being put into the docket. Other artists on UMG who have nothing to do with this, we shouldn't know the contractual details of their agreements. Those things are not supposed to be disclosed to the public. They're supposed to have a certain level of non-disclosure in them if you've ever read a professional recording contract. But I'll continue. This court finds good cause to issue an appropriately tailored confidentiality order governing the pretrial phase of this action. It is hereby ordered that any person subject to this protective order, including without limitation the parties to this action, their representatives, agents, experts, and consultants, all third parties providing discovery in this action, and all other interested persons with actual or constructive notice of this protective order shall adhere to the following terms. Any person subject to this protective order who receives from any other person subject to this protective order any discovery material, i.e., information of any kind produced or disclosed pursuant to and in the course of discovery in this action that is designated confidential pursuant to the terms of this protective order hereinafter confidential discovery material, shall not disclose such confidential discovery material to anyone else except as expressly permitted hereunder. Okay, so there's going to be some sort of punishment given to anyone that leaks out confidential discovery materials. The person producing any given discovery material may designate confidential only such portion of such material, the public disclosure of which is either restricted by law or would cause harm to the business, commercial, financial, or personal interests of the producing person and or third party to whom a duty of confidentiality is owed, and that consists of previously non-disclosed financial information, including without limitation profitability reports or estimates, percentage fees, design fees, royalty rates, minimum guarantee payments, sales reports, and sales margins. Okay, so this would mean that the public shall not be privy to any of these sorts of things, right? Because these are specific contract details, royalty rates, what the artist and the label have agreed to, profitability reports, percentage fees, you know what I'm saying? Minimum guarantee payments. All of these things are vital elements of an artist recording contracts, sales reports, etc. They don't want to put this stuff out there, right? They want it to be available for the purposes of this case, but they don't want us simple folks out here, just having free access to talk about it at the barber shop and on YouTube and just be dissecting everybody's contract. Previously non-disclosed material relating to ownership or control of any non-public company, same deal, about who owns what. Previously non-disclosed business plans, product development information, or marketing plans. Remember, all of these things have been requested by Drake. Any information of a personal or intimate nature regarding any individual, I think that's it. Whoa, personal or intimate nature. Any other category of information hereinafter given confidential status by the court. With respect to the confidential portion of any discovery material other than deposition transcripts and exhibits, the producing person or that person's counsel may designate such portion confidential by A, stamping or otherwise clearly marking confidential the protected portion in a manner that will not interfere with legibility or audibility, and B, if a party seeks to file any discovery material containing confidential information with the court, then within 10 business days after the filing party requests the producing party redact such confidential information, the producing party will redact the confidential information for the filing party to file unless such information was redacted at the time of production. With respect to deposition transcripts, a producing person or that person's counsel may designate such portion confidential either by indicating on the record during the deposition that a question calls for confidential information, in which case the reporter will bind the transcript of the designated testimony consisting of both question and answer in a separate volume and mark it as confidential information. So when it comes to the depositions and certain sensitive questions and answers that shall be marked confidential, nobody will have access to outside of those participating in the case. Okay? Or B, notifying the reporter and all counsel of record in writing within 30 days of the conclusion of a deposition of the specific pages and lines of the transcript and or the specific exhibits that are to be designated confidential, in which case all counsel receiving this transcript will be responsible for marking the copies of the designated transcript or exhibit in their possession or under their control as directed by the producing person or that person's counsel during a 30-day period following the conclusion of a deposition. The entire deposition transcript will be treated as if it had been designated confidential. Okay, so in some cases, they may treat the entire deposition as confidential. If at any time prior to the trial of this action, a producing person realizes that some portions of discovery material previously produced by the producing person without limitation should be designated confidential, then the producing person may so designate by so apprising all prior recipients of the discovery material in writing, and therefore thereafter such designated portions of the discovery material will be deemed to be and treated as confidential under the terms of this protective order. Nothing contained in this order will be construed as a waiver by a party or person of its right to object to any discovery request, or B, a waiver of any privilege or protection, or C, a ruling regarding the admissibility at trial of any document, testimony, or other evidence. So anything that is considered confidential will still be admissible. It's just going to be concealed from us. Where a producing person has designated discovery material confidential, other persons subject to this protective order may only disclose such discovery material or information contained therein, the parties to this action, their insurers, and counsel to their insurers. Counsel retained specifically for this action, including any paralegal, clerical, and other assistant employed by such counsel and assigned to this matter, outside vendors or service providers such as copy service providers and document management consultants, graphic production services, or other litigation support services hired by counsel and assigned to this matter, including computer service personnel performing duties relating to a computerized litigation system, provided such person has first executed a non-disclosure agreement in the form attached hereto. So everybody that's not involved that may have access to this information must also adhere to the confidentiality, right? Any mediator or arbitrator engaged by the parties in this matter or appointed by the court, provided such person has first executed an NDA in the form attached hereto, as to any document, its author, addressee, and any other person indicated in the face of the document as having received a copy. Any witness who, in the good faith belief of counsel for a party, may be called to testify at trial or deposition in this action, provided such person has first executed an NDA in the form attached hereto. So they're going to be giving out NDAs like bubblegum, okay? Any person retained by a party to serve as an expert witness or otherwise provide specialized advice to counsel in connection with this action, provided such person has first executed an NDA in the form attached hereto. Stenographers engaged to transcribe depositions conducted in this action and this court, including any appellate court and the court reporters and support personnel for the same. Before disclosing any confidential discovery material to any person referenced in subparagraph 7C, D, F, or G above, counsel shall provide a copy of this protective order to such person, who must sign an NDA in the form attached hereto, stating that the person has read the protective order and agrees to be bound by it. Said counsel shall retain each signed NDA, hold it in escrow, and produce it to opposing counsel either prior to such person being permitted to testify at deposition or trial, or at the conclusion of the case, whichever comes first. Any party who objects to any designation of confidentiality may, at any time prior to the trial of this action, serve upon counsel for the designated person a written notice stating with particularity the grounds of the objection. If the parties cannot reach agreement promptly, counsel for all parties shall address their dispute to the court in accordance with Rule 6 of this court's individual rules and practices in civil cases. Okay, so if anybody objects to the confidentiality of all of this, then it will have to be seen by the judge. Okay. Any party who requests additional limits on disclosure, such as attorney's eyes only in extraordinary circumstances, may at any time prior to the trial of this action serve upon counsel for the receiving party a written notice stating with particularity the grounds for the request. If the parties cannot reach agreement promptly, counsel for all parties shall address their dispute to the court in accordance with Rule 6 of this court's individual rules and practices in civil cases. Notwithstanding the foregoing, the parties agree that any party may designate as attorney's eyes only any previously non-disclosed contract agreements, contractual terms, clauses, or provisions, and any documents containing excerpts of or substantive discussions about the same, the disclosure of which would be highly likely to cause significant harm to the business or competitive position of the producing party. The parties further agree that defendant may designate as attorneys only any documents identifying confidential or proprietary business information regarding defendants' relationships with other recording artists or non-parties to this litigation, including but not limited to confidential financial or payment information, revenue reports, royalty rates, licensing rates, and any other commercially sensitive documents, the disclosure of which would be highly likely to cause significant harm to defendants' business or competitive position. That would be UMG and their artists. The parties further agree that plaintiff may designate as attorney's eyes only any documents identifying confidential or proprietary business information regarding plaintiff's business relationships with non-parties to this litigation, disclosure of which would be highly likely to cause significant harm to plaintiff's business or competitive position. Any materials designated attorney's eyes only under this paragraph 10 may only be shown to the people in paragraph 7B, C, D, E, G, H, and I. Okay? A party may be requested to produce discovery material that is subject to contractual or other obligations of confidentiality owed to a third party. Within 5 business days of receiving the request, the receiving party subject to such obligation shall inform the third party of the request, and further that the third party may seek a protective order or other relief from this court. If neither the third party nor the receiving party seeks a protective order or other relief from this court within 21 days of that notice, the receiving party shall produce the information responsive to the discovery request, but may affix the appropriate confidentiality designation. Recipients of confidential discovery material under this protective order may use such material solely for the prosecution and defense of this action and any appeals thereof, and not for any business, commercial, or competitive purpose, or in connection with any other litigation or proceeding. Nothing in this protective order, however, will affect or restrict the rights of any person with respect to its own documents or information produced in this action, nor does anything in this protective order limit or restrict the rights of any person to use or disclose information or material obtained independently from and not through pursuant to the federal rules of civil procedure. Hold on for a second, y'all. Let's continue. Nothing herein will prevent any person subject to this protective order from producing any confidential discovery material in its possession in response to a lawful subpoena or other compulsory process, or if required to produce by law or by any government agency having jurisdiction, provided, however, that such person receiving such a request or process shall provide written notice to the producing person before disclosure and as soon as reasonably possible, and if permitted by the time allowed under the request, at least 10 days before any disclosure. Upon receiving such notice, the producing person will have the right to oppose compliance with the subpoena, other compulsory process, or other legal notice if the producing person deems it appropriate to do so. Okay? So they'll have 10 days notice. In accordance with Section 10C of this court's individual rules and practices in civil cases, any party filing documents under seal must first file with the court a letter motion explaining the basis for sealing such documents. So you can't just submit it. You gotta go to the judge, right? The party should be aware that the court will unseal documents if it is unable to make specific on the record findings demonstrating that closure is essential to preserve higher values and is narrowly tailored to serve that interest. The court also retains unfettered discretion whether to afford confidential treatment to any discovery material designated as confidential and submitted to the court in connection with any motion, application, or proceeding that may result in an order and or decision by the court. All persons are hereby placed on notice that the court is unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at trial, even if such material was previously sealed or designated confidential. So again, just because it's confidential in the pre-trial phase, deposition phase, etc., it does not mean that it will be deemed confidential at trial. That is very interesting. I'm sure they're going to fight back on that. In filing confidential discovery material with this court or filing portions of any pleadings, motions, or other papers that disclose such confidential discovery material, the party shall publicly file a redacted copy of the confidential court submission via the ECF system. The party shall simultaneously file under seal via ECF with the appropriate level of restriction an unredacted copy of the confidential court submission with the proposed redactions highlighted. Each person who has access to discovery material that has been designated confidential shall take all due precautions to prevent the unauthorized or inadvertent disclosure of such material. They have to handle it with the highest level of care to not leak it. Any personally identifying information such as social security numbers, financial account numbers, passwords, and information that may be used for identity theft, exchange, and discovery shall be maintained by the persons who receive such information and are bound by this protective order in a manner that is secure and confidential. In the event that the person receiving these experiences a data breach, the receiving person shall immediately notify the producing person of the same and cooperate with the producing person to address and remedy the breach. Nothing herein shall preclude the producing person from asserting legal claims or constitute a waiver of legal rights or defenses in the event of litigation arising out of the receiving person's failure to appropriately protect these personally identifying information, aka PIIs, from unauthorized disclosure. If in connection with this litigation, a party inadvertently discloses information subject to a claim of attorney-client privilege or attorney work product protection, inadvertently disclosed information, such disclosure shall not constitute or be deemed a waiver or forfeiture of any claim of privilege or work product protection with respect to the inadvertently disclosed information and its subject matter. If a disclosing party makes a claim of inadvertent disclosure, the receiving party shall within 5 business days return or destroy all copies of the inadvertently disclosed information and provide a certification of counsel that all such information has been returned or destroyed. Within 5 business days of the certification that such IDI information has been returned or destroyed, the disclosing party shall produce a privilege log with respect to the IDI. The receiving party may move the court for an order compelling production of the IDI. The motion shall be filed under seal and shall not assert as a ground for entering such an order the fact or circumstances of the inadvertent production. The disclosing party retains the burden of establishing the privileged or protected nature of any IDI. Nothing in this order shall limit the right of any party to request an in-camera review of the IDI. This protective order shall survive the termination of the litigation and will continue to be binding upon all persons to whom confidential discovery material is produced or disclosed. Within 30 days of the final disposition of this action, all discovery material designated confidential and all copies thereof shall promptly be returned to the producing person. So even after this case has been closed with whatever verdict it ends up in, all of the material shall remain confidential. Alternatively, upon permission of the producing person, all confidential discovery material and all copies thereof shall be destroyed. In either event, by the 30-day deadline, the recipient must certify the return or destruction of all confidential discovery material and all copies thereof by submitting a written certification to the producing party that affirms that the recipient has not retained any copies, abstracts, compilations, summaries, or other forms of reproducing or capturing any of the confidential discovery material. Notwithstanding this provision, the attorney specifically retained by the parties for representation in this action may retain an archival copy of all pleadings, motion papers, transcripts, expert reports, legal memoranda, correspondence, or attorney work product, even if such materials contain confidential discovery material. Any such archival copies that contain or constitute confidential discovery material remain subject to this order. All persons subject to this protective order acknowledge that willful violation of the protective order could be subject to them for punishment for contempt of court. This court shall retain jurisdiction over all persons submitted to this protective order to the extent necessary to enforce any obligations arising hereunder or to impose sanctions for any contempt thereof. And as you can see here, this is where the signatures are supposed to be from each party. We have none. And at the beginning of the video, we told you that Judge Vargas said that this is not satisfactory. You need to re-upload this with your signatures. And this was uploaded by Drake. here we have an attached NDA, okay? So this is for anybody entering into the protective order with discovery material that may be deemed as confidential. They will have to sign on to this NDA, okay? So once again, that is the jointly filed protective order filed by, well, uploaded by Drake, but allegedly both parties have agreed to these terms, as in UMG and Drake. However, it has been submitted with no signatures on it to execute it to be moved forth. So the judge at this point denied it and told Drake and his lawyers to re-upload this with signature lines complete so that we can move forward. Okay, so that's what's going to be the next thing, and we'll see what comes next in the coming weeks. It may just go radio silent. I don't know. I don't know what all paperwork needs to be uploaded from the parties in the between time, but I do think Drake has until the end of the month to file his paperwork to show why UMG's motion to dismiss is inadequate and should move forward. Okay? Let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider, and I will catch y'all on the next one. Much love and respect, y'all. Peace.
King of my city and cul-de-sac. Coming out swinging like soldier rag. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef on computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. But drama, I'm fully abreast. I was ready for years and they died of me. All of a sudden they tell me they proud of me. I been dropping these haters like calories. Cross them out, I came back with some boundaries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.